Good evening, friends. Since we started the journey of sharing the knowledge on the channel of Beyond Law CLC, a lot of persons from Karnataka had requested that we should bring in Justice Sreenivas Harish Kumar, a former judge of Karnataka High Court, to share his knowledge. And after demitting his office, we requested him, and he has been kind enough to accede to our request to take us to an important facet of law and understanding all the civil appeals, meaning, scope, and procedure under CPC. As we all know that the first appeal and second appeal, what are the trappings in respect of that? And how do you appreciate the evidence and what is the scope within that? This is the legal journey which we take across in a journey of around 45 minutes, and then we will have a question and answers. We are thankful to Tripura and Associates and Ma'am Sushila, a senior advocate, for helping us to connect with Sir. It is an immense pleasure to introduce him. And over to you, sir, for accepting our invite. Thank you.
Thank you. Good evening to all of you. I think Mr. Chatra is behind me for the last 3 or 4 months. For some such reasons, I could not accept his request in the beginning. And at last, I agreed to speak on the subject appeals, civil appeals. So today, for about 45 minutes or 1 hour, I deal with first appeals. I confine my speech to first appeals, section 96 under order 41. Though appeal is a vast subject, second appeals are there, appeal from orders. So I don't think the time will permit to deal with the second appeal and appeal from orders. Therefore, I am confining my lecture to first appeal under section 96, corresponding order 41 of CPC. Now, whenever I took classes in the academy for the trainee judges, I would put a question to them as to what is the meaning of the appeal. Unless the meaning of the word appeal is understood, I don't think that an advocate cannot properly argue on the appeal, or a judge can decide an appeal in the way it is to be decided. I used to get answers, different answers. Someone says appeal is a legal right available to a party. Somebody says it is a continuation of suit. The other answer I got was that a right of an aggrieved party to a suit to approach next higher court. All these answers may be right, but they do not convey exact meaning neither in CPC nor in CRPC. We find appeal having been defined. So if an attempt is made to define the meaning, I just say that appeal is nothing but complaint against judgment of the trial court or any order wherever an order can be appealed. So an appeal is nothing but a complaint of the trial court, complaint against the trial court. We can gather this meaning from subrule 2 of rule 1 of order 41. It says, subrule 1 says, subrule 2 says that memorandum shall set forth concisely and under distinct heads the grounds of objection to the decree appealed from without any argument or narration. That means grounds of objection means objection to the decree or judgment appealed from. So objection here is nothing but complaint against the judgment of the trial court. So if it is a complaint, if it is an objection, appellate court must examine whether objection taken on a finding is sustainable or not. It is a genuine objection or not. This is the exercise that an appellate court must do. There is a proposition that appeal is continuation of a suit. Because of this proposition is correct. I do agree with it. But it is not properly understood. I have seen advocates arguing an appeal in the way they argue in a suit. And I have seen judges writing judgments in the appeal like they write in the suits. This is not correct. Therefore, now within the time available, I make an effort to analyze the entire concept of appeal. The first question is, who can prefer an appeal? Answers: the party to a suit aggrieved by the decree of a court can prefer an appeal. It is his right. It is his right, no doubt it is his right. Secondly, legal representative of a party has a right to prefer an appeal. Whenever a legal representative prefers an appeal, there is no need to take leave of the court by making a separate application. Thirdly, a person who is not a party to the suit can prefer an appeal, but he cannot prefer an appeal without leave of the court. And he must demonstrate as to how he is aggrieved by the decree. So a third party can also prefer an appeal, but without leave of the court, he cannot prefer. And he must make an application setting forth his interest in the subject matter of the suit and demonstrate his grievance, how he is aggrieved by the decree. If the court is satisfied, leave will be granted. Otherwise, he is not permitted to prefer an appeal. Then, appeal shall be preferred in the form of a memorandum signed by the appellant or his advocate. This is not a verified statement. So verification affidavit is not necessary. It is enough if the appellant or his pleader signs the memorandum of appeal. The grounds that can be taken in the appeal must arise from the pleadings and evidence that are necessary for decision of the case. So, a fact which is not pleaded, evidence which has not been brought on record, evidence which has not been discussed with the trial court, cannot constitute a ground in the appeal. A point not taken in the pleadings cannot be contended in the appeal. A point which is taken in the pleading but not urged in the trial during the course of trial or abandoned cannot be allowed to be taken in the appeal. Then a question may arise, what is the point that can be taken for the first time in an appeal? If it is a pure question of law, just like limitation, supposing that question of limitation is not urged in the trial court, and in the appeal, question of limitation can be urged because it's a question of law. If the court lacked inherent jurisdiction to entertain the suit, that can also be questioned in the appeal because it touches the jurisdiction of the court. When I say jurisdiction, it is not territorial or pecuniary. It's inherent lack of jurisdiction. That means court cannot entertain. The court is debarred from entertaining any suit. Then if statute demanded a notice to be issued, it was not issued, yet the suit was entertained, decided. That question can also be taken for the first time in the appeal. Now, plea of res judicata is, of course, a question of fact, but if it can be apparently demonstrated from the record before the court that suit was hit by res judicata, and that point was not urged there, that point can also be for the first time taken in the appeal. A question would arise whether a ground not taken in the memorandum of appeal can be urged to be heard. That means a ground is not taken in the memorandum of appeal. During argument, a new point or a new ground is sought to be introduced. The answer is that yes, a new ground can be taken, but with the permission of the court. But there is no restriction for the court to take into account any point not taken by the parties. That means the court can of own accord can decide an appeal on any point not traversed by the parties. But if the court wants to point out any ground not urged by the parties, it must be brought to the notice of the affected party. That means by bringing to the notice of the party or the advocate that here is a point which the advocates have not urged, but it can be urged. And if it is considered, it may go against a party, it may go in favor of a party. It must be brought to the notice of the advocates, and then such a point can be decided. Can the appellate court permit amendment to the memorandum of appeal? Is the next question. Definitely, memorandum of appeal can be amended only to cure the defect. Rule 3 of 41 states that court can permit amendment to the memorandum of appeal to cure a defect. So whenever an application is to be made for amending the memorandum of fact, the application must be made under 41 Rule 3, not under Order 6 Rule 17, because Order 6 Rule 17 permits amendment to the pleadings, not to the memorandum of appeal. Supposing that appellant wants to urge a new ground by amending the memorandum of appeal, though there is no specific provision, but if rules 2 and 3 are read together, we can definitely say that appellate court can permit a new ground being taken in the appeal memo or the memorandum of appeal by amending it. Then there is a limitation for preferring the appeal. If it is to be preferred to the High Court, limitation is 90 days. If it is to any other court, 30 days. In case an appeal is preferred beyond the prescribed time, an application for condonation of delay has to be filed. Rule 3A of Order 41 deals with it. That application is nothing but an application under Section 5 of the Limitation Act. I have seen, while dealing with appeals, sitting as a judge of the High Court, when I saw the application for condonation of delay, hardly I came across the actual reason for the delay. If the affidavit ran into 3 or 4 pages, from para 1 to say 3 or 4 paras, full of narration of facts of the case, and then in the last para, some reason stating that the delay is not intentional, therefore it can be condoned. That's all. I did not find application being drafted in the way it should have been. All that I want to say is an application for condonation of delay must indicate the actual reason for the delay. Sufficient cause is to be shown for the condonation of delay. It's not necessary to set forth the facts of the case, not at all required. Affidavit must contain only the reasons which prevented the appellant from approaching the court within the time prescribed. If such reasons are given, if the court finds that the reasons are sufficient, delay can be condoned. Otherwise, delay will not be condoned, which results in dismissal of the appeal. Now, what the judges dealing with the appellate, sitting in an appeal do while entertaining an application for condonation of delay. Judges must go through the application. They must examine whether delay has been explained or not. If delay appears to have been explained, a notice must be issued to the respondent. And after appearance of the respondent, if the respondent files statement of objections, considering the affidavit filed along with the application and the statement of objection, the court can decide whether delay can be condoned or not. But if on the face of the application, it appears that application does not disclose sufficient cause for delay and no convincing reasons are given, the court need not order notice to the respondent. So without issuing notice, application can be dismissed. Thereby, appeal will not be entertained at all. So these are the two courses open. If on the face of it, application does not disclose good reason, sufficient cause, court need not issue notice to the respondent. It can be dismissed. If the court finds that delay is explained and respondent also is required to be heard, then only notice can be ordered. And after hearing both the appellant and the respondent, that application can be decided. But it should be borne in mind that unless delay is condoned, there cannot be stay of the decree. If at all an application for stay is made and there is delay in filing the appeal, first delay must be condoned, and then the appeal must be heard under Rule 11 of Order 41. Only if it appears that the appeal is worth admission, then only stay can be granted if the decree appealed is an executable decree. Otherwise, stay cannot be granted. Now, so far as stay is concerned, Order 41 Rule 5 deals with it. No doubt, Appellate Court has every power to grant stay of the decree which is challenged in appeal. But it must be noted that mere filing of appeal does not operate as stay. Stay can be granted when there is executable decree. Blanket order of stay cannot be granted. Sub-rule 3 of Rule 5, Order 41 states, the appellant must demonstrate that he suffers substantial loss if decree is not stayed. Number 2, application for stay must have been without delay, and he must be ready to furnish security for due performance of the decree or order. That means while granting stay, the appellate court can impose conditions. He may require the appellant to furnish security for the due performance of the decree. Usually in money suits, wherever a money decree is appealed, appellate court directs the appellant to deposit a part of the decretal amount as a condition for stay of the decree challenged. Even ex parte stay can be granted by the appellate court by imposing appropriate conditions. It all depends on the nature of the decree. One thing I want to say here that suit is dismissed. Obviously, plaintiff is the appellant. So when a plaintiff prefers an appeal, I have seen an application of 41 Rule 5 being made, seeking stay of the judgment or decree. When I put the question, when the suit is dismissed, what is there to be stayed? The answer was like this. Answer was like this. There was an order of injunction, temporary injunction, during pendency of the suit. It was in force till the suit was decided on merits. Now, if the decree is stayed, the order of injunction would revive. That was the answer I was getting. This answer is not correct. So whenever an appeal is preferred by a plaintiff when his suit is dismissed, he has no right to prefer an application of 41 Rule 5. If at all there was an interim order of injunction, temporary injunction, or an attachment before judgment, or any other order till disposal of suit on merits, the proper course would be that the appellant must apply for temporary injunction or any other order to be passed in the appeal, which the appellate court can pass. So, if decree is stayed, it does not mean that the interim order that was in force in the suit would get revived. that concept is wrong. Therefore, a plaintiff who prefers an appeal cannot seek for stay under Article 41 Rule 5. The remedy open to him is to apply for the interim order that was in force. Now, while granting stay, whenever there is executable decree, the appellate court must insist on providing security. The stay order must indicate that stay will not come into force unless security is furnished within a given time. So automatically, if security is not furnished within the given time, automatically the order would get vacated. Now, Rule 6 has got some importance. Out of 41, Rule 6 has got some importance. Supposing that appellant fails to get an interim order of stay in the appeal, or by the time appeal is preferred and an application for stay is made, if decree has been executed, then the appellant can approach the court of first instance with a request to the court that the respondent who has executed decree must furnish security for restoration of the property. That means even though he fails to obtain a decree, stay order in the appellate court, from the appellate court, he can very much make use of Rule 6 for a direction to the decree holder to provide security for the restoration of property, which the possession of which or something has been done so far by virtue of the decree. So this hardly have seen Rule 6 being used by any appellant. It has got its own importance. So after this, next important rule is Rule 11 of Order 41. It is a provision which enables the appellate court to dismiss the appeal in limine. That means not to entertain appeals which are meritless. So the appellate courts can dismiss the appeal even without issuing notice to the respondent, provided, but it must appear to the appellate court that the appeal is hopelessly meritless. Though this power is available to the first appellate court, the established principle is that court must be slow in exercising the power to dismiss the appeal at this stage, as the first appellate court is the last fact-finding body. That means in the appeal, first appeal, because there is a need to reappreciate the facts and evidence, if the appeal is dismissed, exercising power under Rule 11, many a time it may lead to injustice being caused. So it is better to be slow at the time of admission. So because of the reason that the first appellate court has to reappreciate the entire evidence, the judges go slow so far as while exercising the power under Rule 11. But if the case appears to be hopeless, meritless, there is no better to dismiss the appeal, exercising power under Rule 11, even without securing the presence of the respondent. Then, once the appeal is admitted, Rule 16 says that appellant has a right to address the argument first. He has a right to commence. Here also, law provides that after hearing the appellant, if the court thinks that there is no need to hear the respondent, appeal can be dismissed. That means after hearing the arguments from the appellant side, if he fails to make out a good case, so without hearing the respondent, appeal can be dismissed. And after hearing the appeal or appellant, if it finds, court finds that yes, respondent is also required to be heard, or no final decision can be taken without hearing the respondent, then the respondent is to be heard. That means the court must entertain a feeling that a definite conclusion can be drawn only after hearing the respondent. Then only a need to hear the respondent arises. Therefore, in a situation like this, both the appellant and respondents are heard, and then the court will take a decision. Rule 17 gives the power to dismiss the appeal for default or non-prosecution. If the appellant fails to appear and address argument, appeal has to be dismissed for default or non-prosecution. But for no reason, appeal can be decided on merits. Explanation to Rule 17 says that if appellant fails to address arguments, it does fail to appear before the court, then the appeal has to be dismissed for non-prosecution. A court cannot decide the appeal on merits. Similarly, if respondent does not appear, appellant can be heard and judgment can be given. Now, Rule 19 is a provision that enables an appellant to apply for readmission of the appeal whenever it was dismissed for non-prosecution. And Rule 21 is a provision that enables the respondent to apply for rehearing of the appeal. If the appeal was heard and decided in his absence, that is ex parte, he can apply to the court for rehearing of the appeal. But I have seen whenever appeal was heard and decided, in the absence of the respondent, some of the advocates came up with application for a review of the judgment. The ground being that because respondent was not heard, the judgment requires to be reviewed. I don't think that is a correct approach, because if the appeal is decided in the absence of the respondent, Rule 21 clearly states that respondent can apply for rehearing of the appeal. Review is not permitted in a situation like this. So if Rule 19 is akin to Order 9, Rule 9, and Rule 21 is akin to Order 9, Rule 13 of CPC. Rule 22 is a very important provision. According to this Rule 22, we can see two situations. A respondent can question a finding of fact, a finding which is not favorable to him. And he can also put forward cross objections. I will just explain this context, the scope of Rule 22. in an appeal, respondent appears. That means the decree of the trial court is in his favor. Just because he is a respondent, it doesn't mean that he cannot question in the same appeal a finding of the trial court on a particular issue which has not come in his favor. He is also entitled to prefer a cross objection. So when a respondent can question a finding, when he has to prefer a cross objection or cross appeal is the question. So this can be better explained if I give some instances, examples. Supposing that A sues B for, A brings a suit against B for specific performance, and in the suit, he claims alternative relief of refund of earnest money. Court denies the relief of specific performance, but grants the alternative relief of refund of earnest money. Now, in a situation like this, if A files an appeal aggrieved by decree of denial of specific performance, B, if he wants to question the decree of grant of alternative relief, he has to file cross objections. I think I have made myself clear. The suit is for specific performance. In the suit, the plaintiff A claims the relief of specific performance in the alternative for refund of earnest money. The court does not grant the relief of specific performance, only grants the alternative relief of refund of earnest money. Now A, the plaintiff, being aggrieved by denial of the relief of specific performance, prefers an appeal. In that appeal, B appears. If he is aggrieved by the judgment of granting the alternative relief, he has to file a cross objection because he is questioning the very decree of granting the alternative relief. He has to file cross objections. Supposing in the suit B, a suit for specific performance, B has taken a contention that the suit is barred by time limitation question, and trial court has framed an issue with regard to limitation. Trial court holds that suit is not time barred, but dismisses the suit on merits. That means the final judgment decree is in favor of the defendant. Suit having been dismissed, it has gone in favor of the defendant. Now the aggrieved party is the plaintiff. If he prefers, then in the suit, the defendant B, without there being need to file cross objection, can question the finding of the trial court on the issue of limitation. I think I have made this point clear. So another example is in a suit for partition, plaintiff claims partition in, say, in 10 properties. Court partially decrees the suit, granting partition in 5 properties and dismissing the suit so far as other 5 are concerned. Now, if the plaintiff files an appeal aggrieved by denial of partition in 5 properties, the defendant, being the respondent in the appeal, has to file cross objections if he wants to challenge the decree of granting partition in 5 items. Or if the defendant files an appeal questioning the decree of granting partition in 5 items, the plaintiff, being the respondent in the appeal, has to file cross objection for the denial of the decree in respect of the other file. In other words, cross objection is not necessary if challenge is to a mere finding on an issue which does not have bearing on final decision in the suit. Whenever respondent claims a relief against appellant in the appeal, cross objection is to be filed. If mere finding is challenged, though ultimate result in the suit is in favor of the respondent, he did not file cross objection. He can just question a finding on an issue against him. So this is the scope of Rule 22. And since cross objection is nothing but an appeal, limitation is 30 days from the date of service of notice of the appeal on him. If delay is there in filing the cross objection, condonation has to be sought. And court fee should also be paid on the cross objection. So cross objection is nothing but an appeal. Therefore, if main appeal is dismissed for non-prosecution, or if the appellant withdraws his appeal, cross objection will continue. It can be heard on merits and decided. So cross objection is nothing but an appeal, and it can be filed a party who could have filed an appeal independently. But cross objection is not usually allowed against a co-respondent in an appeal. That is the general principle. A respondent in an appeal cannot file cross objection against a co-respondent. But in certain types of suits, like dissolution of partnership or partition, where plaintiff is treated as a defendant and defendant is treated as a plaintiff, cross objection is permitted against co-respondent. So this is all about the scope of Rule 22. Next provision is remand. This is very important because the appellate courts are found to have exercised the power of remand very generously. But scope of remand is confined to Rule 23 and Rule 23A of Order 41. Explain the scope of remand. Unnecessary remands must be avoided by the appellate courts as far as possible. Appellate courts have to decide the appeal. Appeal is a continuation of suit. Why it is the proposition is like this, you will understand that proposition if we go through the provisions, Rule 23, 23A, 24, 25, 26 and 27, 28, 29. So remand of a case is permitted according to Rule 23 only when suit is decided on a preliminary point. That means, for example, plaint is rejected under Order 7, Rule 11 CPC. So rejection amounts to a decree. Appeal can be preferred. So when a plaint is rejected under Order 7, Rule 11, though it amounts to decree, there is no finding on facts. So in case appeal is preferred in a situation like this, if the appellate court finds that rejection of plaint was not proper, then the course open is to allow the appeal. And for the purpose of all the issues being answered by the trial court, the case is to be remanded. Here the suit was dismissed on a preliminary point. Plaint was rejected either under Order 7, Rule A, B, C, D, E, F, like that, or any one of the grounds may be, enables court reject a plaint. So it is a finding, a preliminary finding, which does not touch the merits of the suit. Similarly, if suit is dismissed as not maintainable because for some reason, if appeal is preferred, the order of the court is reversed, the case has to be remanded. And if the suit is dismissed saying that civil court has no jurisdiction or suit is not of a civil nature, there is no finding on the issues. Therefore, in the appeal, if the judgment of the trial court is reversed, then there is a case for remand. This is the scope of Rule 23. Now, 23A is another provision for remand. This is applicable when a suit is disposed of other than at a preliminary point and wherever retrial is held necessary. To illustrate, supposing suit is decreed ex parte, so defendant prefers an appeal. Section 96 of CPC says that even an ex parte decree can be questioned in an appeal. So instead of preferring an application under Order 9 Rule 13 CPC, defendant prefers an appeal. There he takes up the ground that he was denied of an opportunity to contest the suit. And he makes out a good ground as to what prevented him from appearing before the trial court. So in that event, if the appellate court finds that the defendant has good reason and he too requires to be heard, so obviously the judgment requires to be set aside. And since there was no contest from the defendant side, then the case has to be remanded to the trial court to enable the defendant to file his written statement, framing of issues, and read at the trial on all the issues that the court may be going to rise. So here the trial is necessary. So this situation falls within the scope of Rule 23A. In a situation like defendant appears in the suit, files written statement, but fails to cross-examine the plaintiff's witnesses, suit gets decreed, defendant prefers an appeal. So this is a case that falls within the scope of Rule 23A. In case appeal is allowed and there is a scope for remand, because here the suit is not decided on preliminary point but on facts, because when a suit is decreed based on the plaintiff arguments, based on the case that the plaintiff makes out, there is a finding on facts. So actually the case is not decided on preliminary point. Therefore, the scope of Rule 23A is that wherever there is scope for remand on the facts which do not constitute a preliminary point, then only the appellate court can exercise power under Rule 23A. So barring these two circumstances, there is no scope for remand. Then whenever remand order is made, court has to fix a date for appearance of the parties before the trial court. This will avoid unnecessary delay. If date is not fixed, after receipt of the records, the trial court has to issue notices or summons to the parties once again and secure their presence. Instead, if the appellate court fixes the date, that will avoid the delay. Then I go to Rule 24, which is also an important provision. In the course of hearing the appeal, if the appellate court feels that the trial court has not framed the issues properly and thereby the issues are to be resettled, reframed. Then the appellate court can certainly reframe the issues or frame an issue, a new issue. Here also there is no scope for remand. So once issues are resettled or reframed, and if the court thinks that in spite of issues being resettled, the evidence available on record is sufficient, with the help of which appeal can be decided, the appellate court can decide the appeal on merits. So there is no scope for remand here. Issues are resettled, reframed, but evidence is available, sufficient evidence is available, then only appeal can be decided on merits. Now, Rule 25 says that supposing that an issue is framed, a new issue is framed, or new issue is framed, thinking that the trial court ought to have framed an issue, it has not framed, then the appellate court frames an issue. On that issue, evidence is not available. Therefore, what the appellate court should do is, after framing a new issue or an additional issue, the trial court should not remand the case to the appellate court should not remand the case to the trial court. The procedure is like this. The appeal must be retained before the appellate court. The trial court records must be transmitted to the trial court. Records of the trial court of the suit must be transmitted to the trial court and direct the trial court to record evidence on the new issue and give finding. That means whenever a new issue is framed by the appellate court has to send the records of the suit to the trial court, direct the trial court to record evidence on that new issue and give finding. Afterwards, the trial court must submit the records to the appellate court. Rule 26 now comes into picture. So the findings of the trial court must be brought to the notice of the parties, that is appellant and the respondents. Whoever wants to prefer objections to the findings on that new issue can prefer objections. After this process is over, the appellate court must decide the appeal. That means without remanding the case to the trial court, the appellate court can decide the appeal based on the findings on the issues which the trial court had framed and based on the new issue which the appellate court framed and required the trial court to record a finding on that issue. So everything shall be done by the appellate court itself. There is no scope for remand here also. So the appeal papers remain in the appellate court. Only the trial court records will be transmitted to the trial court. So the evidence recorded will be secured and then the appeal will be decided on merits. Now, if this is about framing of the issues, resettlement of the issues, Rule 27 empowers the appellate court to receive additional evidence. I have seen many appeals being remanded, in many appeals, once additional evidence is received, cases having been remanded to the trial court for decision on merits afresh. This is a wrong approach. Because Rule 27 doesn't speak about remand. Scope of Rule 27 is this much. No doubt appellate court can receive additional evidence either in the form of documents or by permitting a party to plead evidence. So whenever an application for additional evidence is made, the party who applies for additional evidence, receiving additional evidence, must make out one of the three circumstances. Number one, he must say the trial court must have refused to admit evidence. Those are to be produced. That means either a plaintiff or defendant might have made an attempt to produce evidence. The trial court should not have received the evidence. Number two, party seeking to produce additional evidence must establish that in spite of being diligent, the evidence which he now wants to introduce by way of additional evidence was not within his knowledge, or he could not produce it. If this ground is made out, additional evidence will be received. Thirdly, if the appellate court finds that for doing justice, for a substantial cause, yes, additional evidence is necessary, it can receive the evidence. The established principle is that whenever an application for additional evidence is made, it must be decided along with merits of the appeal. There is no scope for deciding the application separately before hearing the appeal on merits. If the application is decided separately without hearing the appeal on merits, it is a wrong procedure. Reason is this: the appellate court has to decide whether additional evidence is to be received or not. So when this will become clear, so when the appellate court hears the argument on merits, goes through the evidence, appellate court will come to know, yes, there is a scope for receiving additional evidence, or the evidence available on record is itself sufficient for deciding the appeal. That means unless the appellate court goes through the entire evidence, it will not be in a position to apply its mind to the application for additional evidence to decide whether to receive or not to receive. Therefore, the rule is that the application for additional evidence must be considered along with merits of the case. Now, what is a procedure? Supposing that application is allowed, what is the next procedure? How to decide an application? Now, before I go to the next procedure, how to decide an application under Art 41, Rule 27. So here the application along with merits. If it is found that, if the appellate court finds that application cannot be granted, that means application has to be dismissed. Judgment on appeal can be pronounced. So when the application appears to be worth dismissal, the appeal can be decided on merits. In case additional evidence is to be received, the appellate court is of the opinion, this additional evidence is to be received. Procedure is like this. What I used to do is this: postpone the pronouncement of judgment, allow the application, and then proceed in accordance with rules 28 and 29 of Order 2041. So, appellate court allows the application. Then next procedure is Rule 28 and 29. That means judgment is not pronounced, only application is allowed to enable a party to produce additional evidence. Then after receiving the additional evidence, the appellate court must hear the arguments once again, then decide the appeal. Now what Rule 28 and 29 says is, the appellate court can itself take additional evidence, or appellate court can direct the trial court to record additional evidence, or appellate court can direct any court subordinate to it to receive evidence and send the recorded evidence. That means whatever is to be done, it must be decided at the appellate stage itself. I stress here that there is no scope for remand what the appellate courts are doing, majority appellate courts are doing, once additional evidence is received, remand the case. That is not permitted, because appellate court can itself receive the additional evidence or can direct the trial court to receive additional evidence. Directing trial court to receive additional evidence does not amount to remand. And or in the alternative, the appellate court, instead of directing the trial court, can direct any court subordinate to it to receive additional evidence. So it is better that the appellate court itself receives the additional evidence. Once application is allowed, if a question is put to the other side, supposing that appellant wants to produce the additional evidence, and after application is allowed, a document is sought to be produced. If the respondent is questioned whether he has got any objection to mark the document, or the appellant can also be questioned, is there any oral evidence to be given on the document? Then if the appellant says yes, oral evidence is necessary, then only oral evidence can be recorded, or trial court can be asked to record evidence. Otherwise, the document can be straight away marked in the appeal and looked into. Now, when the records are sent to trial court for the purpose of receiving the additional evidence, Rule 29 says that appellate court must specify the points on which additional evidence is to be received. If this specification is not made, if the appellate court does not give a direction like this, there are all chances that parties will try to lead fresh evidence on all the issues. So to avoid this, the appellate court, once it receives, allows an application for additional evidence, must direct the trial court or any other court to which it sends the record, confine the recording of evidence only to this point. So once evidence is recorded, the court must submit the records to the appellate court. So with the help of the evidence, then the appeal must be decided. So it is needless to say further that once additional evidence is produced by one party, the other party has to be given an opportunity to lead rebuttal evidence on the additional evidence that has been brought on record. This is a procedure. So far as Order 21, Rule 27 is concerned, one may put a question, is there not scope for remand once application under 41 Rule 27 is received, is allowed? I don't deny it. Yes, there is a scope for remand provided the situation either under Rule 23 or 23A is made out. If the case does not fall within the scope of these two rules, 23 and 23A, there is no scope for remand. If additional evidence is brought on record, it is the duty of the appellate court to decide the appeal with the help of additional evidence. Now, the difference between Order 41, Rule 24 and 25 on one side, and Order 41, Rule 27 is this. If an issue is raised for the first time in the appellate court, or the issues are resettled, there the appellate court will direct the trial court to record evidence on the issue and give its finding. But whenever additional evidence is received, the appellate court will not direct the trial court to give a finding. This is the only difference. Once additional evidence is received, the trial court or any other court subordinate to the appellate court will just record evidence and send back the records to the appellate court. There is no finding. This is all the difference. So if there is scope for giving a finding wherever issue is framed, according to Order 41, Rule 27, trial court cannot give a finding even though it records the evidence. Then I go to Rule 31. That is points for determination. Rule 30 deals with judgment by appellate court. It is better to read Rule 31 first and read Rule 30 later. So points for determination must be framed based on actual grounds urged by the parties or their counsel. For this, the appellate court must read the memorandum of appeal, consider the actual points contended during arguments, frame the points for determination, confining to the actual point of controversy. Why I want to stress here, what I want to stress here is, whenever I sat on the second appeal, I have seen some of the appellate judges, first appellate who have dealt with first appeals, framing the points like issues. What Rule 31 says is the appellate court has to frame a point for determination. It does not direct to frame an issue. Trial court has already framed an issue. Finding is there. And in the appeal, objections are taken to findings of the trial court. That means while hearing, the advocates will point out this is the mistake committed by the trial court. The evidence is like this. Facts are like this. Evidence is like this. So the finding should have been like this. So based on the arguments that the advocates advance, put forward before the court, or the grounds that are taken in the memorandum of appeal, points are to be framed. Probably under the impression that appeal is continuation of suit, points are raised just like issues. Yes, no doubt, appeal is a continuation of suit, but points for determination should not be framed like issues. I have also seen some appellate judges framing the questions, points very generally like this. Whether the judgment of the trial court is arbitrary, capricious, etc., or whether the judgment of the trial court requires to be interfered with. Just one point. This is incorrect. This is not the way how point is to be raised. I just show how points are to be raised. Supposing in a suit for declaration based on will, finding of the trial court is that execution of the will is proved, and that finding is questioned in the appeal. Argument is advanced that the finding of the trial court about execution of the will is wrong. The trial court has gone wrong in giving a finding. Then the point that would arise in the appeal is like this. Has the trial court correctly held that the execution of will has duly been proved? If the point is raised like this will focus on the controversy, that is the subject matter of the appeal. And then in a partition suit, if there is a relationship of the plaintiff is disputed by the defendant, saying that plaintiff is not the member of the joint family, and therefore he has no right to seek partition. And if the trial court gives a finding that the plaintiff is a member of joint family, and if it is challenged in the appeal, the point to be framed is like this. Is the finding of the trial court that plaintiff is a member of joint family correct? This is how the points are to be raised. The appellate courts should not frame the points just like issues in the suit, or should not raise the general points as I referred to already. Now, the trial court might have framed several issues, including about the joinder of parties. The suit is bad for misjoinder of parties, non-joinder of parties, like that. An issue may be on the limitation may be there. An issue on the territorial jurisdiction or peculiar jurisdiction may be there. But in the appeal, if all these issues are not urged, having raised issue on the question of limitation, if it is not urged in the appeal, if the issue with regard to joinder of parties is not urged in the appeal, in my opinion, there is no need to decide the appeal on these aspects, because neither the appellant nor the respondent is interested in raising the questions, these aspects in the appeal. Why should the appellate court waste its time by answering all the issues? Yes, it is said that appellate court should decide all the issues. Here, all the issues, I mean only issues that are decide the suit. Only those points, those issues upon which controversy is raised, objection is taken in the appeal, are to be answered, not all the issues. All the issues means the issues that are made subject matter of the appeal. This is the scope of Order 31, Rule 31. If points are not properly framed, there is no proper judgment. There cannot be finding on the actual point of controversy. Then, according to Rule 30, judgment is to be delivered by framing the point of the determination, reasons. So, if the appellate court does not give reasons, it is no judgment at all. Therefore, all the points that are raised for determination are to be answered. Now, the advocates, while arguing on the appeal, I have seen advocates arguing the appeal, arguing just like they argue in the suits, forgetting that they are arguing in an appeal. Nothing prevents the advocates from bringing to the notice of the court that this is the actual point of controversy. It's enough if this point is decided. In my opinion, that is permitted. To support my I refer to Rule 32 of Order 41. We get an inkling here. It says the parties to the appeal may agree as to the form which the decree in appeal shall take, or as to the order to be made in appeal. That means what? If an interpretation is given, the advocates may make a submission before the appellate court. These are the points upon which we want a judgment. So please, we confine our argument to these points. So give judgment in the appeal on these points. This is the scope, in my opinion. This is the scope of Rule 32, in my opinion. Then, very important provision in our entire 41 is Rule 33, which is molding of a relief by the appellate court. It's almost akin to Order 7, Rule 7, CPC. It can be said that appellate court has got a wider power than the trial court to mold the relief. Molding the relief means giving proper relief which the party requires. Ample power is given to the appellate court. Suppose in a suit for declaration, if the court feels that actually instead of declaration, it is better to give partition decree, if pleadings are there to that effect, certainly the appellate court can mold the relief. Instead of granting declaration, partition decree can be granted. Like that, relief can be molded provided there is foundation in the pleadings. Order 33 also says that appellate court can exercise power in favor of all or any of the respondents or parties who have not filed cross objection or appeal. Supposing that there are two defendants, out of them only one defendant appeals aggrieved by decree against him and another defendant who does not prefer the appeal. Now, in the appeal, the plaintiff and another co-defendant will be party respondents. The court thinks that appeal is to be allowed, then relief can be granted not only in respect of the defendant who has preferred an appeal, but also a defendant who has not preferred the appeal. So relief can be molded like this. A relief which can be granted, ought to have been granted in the suit, can be granted in the appeal. A respondent who has not preferred an appeal or cross objection, in his favor also there can be a relief. This is the scope of Rule 33. Appellate court has got ample powers, power wider than the trial court can exercise. So if Rule 33 is made use of, in my opinion, substantial justice can be done. So Rule 33 has to be read along with Rule 4 of Order 41. For benefit of the audience, I read Rule 4. Rule 4 says, where there are more plaintiffs or more defendants than one in a suit, and the decree appealed from proceeds on any ground common to all the plaintiffs or to all the defendants, any one of the plaintiffs or the defendants may appeal from the whole decree, and thereupon appellate court may reverse or vary the decree in favor of all the plaintiffs or defendants as the case may be. Now, if this Rule 4 is read along with Rule 33, it can be gathered or it can be understood that the appellate court can grant any relief that the parties actually require, provided with confining its examination to the pleadings brought before the court. If there is no foundation for the relief to be granted in the plaint or the written statement, relief cannot be molded even by exercising Rule 33. That means pleadings must be there. Instead of claiming a relief in the way it is to be claimed, if some other relief is claimed, and in the appeal, if the appellate court feels that this is the actual relief that the party is entitled to, that can be granted. So this is the scope of Rule 33. Then, for the benefit of the appellate court judges, how a judgment in the appeal is to be written. Briefly state the facts, make reference to the issues. It is not necessary to extract all the issues. You may refer to only such issues which decided the case. Then refer to the findings of the trial court, because you are examining the correctness of the judgment of the trial court. So in the judgment of the appeal, the findings of the trial court must be referred to. Whether it is correct or not, it must be stated in the appellate court judgment. Then after referring to the findings, refer to the points of arguments put forward by the advocates, appreciate the evidence on the issues upon which points for determination are framed, then give your findings. If the trial court has appreciated the evidence correctly and its findings are correct, there is no need to write a lengthy judgment. Only when the appellate court wants to differ from the findings given by trial court, then reasons must be supplied. First, don't read the judgment of the trial court. Read the plaint, read the written statement, go through the issues, go through the entire evidence. You form an opinion. If your opinion is same as the opinion of the trial court, then appeal is to be dismissed. If your opinion differs from the view taken by the trial court, then appeal has to be allowed. So their exercise is a bit more. We must supply proper reasons. So if this is done, it is a good judgment on the appeal side. Now, on the proposition, appeal is continuation of suit. Nowhere it is, one finds the explanation. From my experience, I say appeal is a continuation of suit because of these reasons. One, appellate court can exercise all the powers that a trial court can exercise. It can frame an issue, it can resettle an issue, it can reappreciate the evidence, it can take additional evidence, and it can mold the relief in the proper form. Therefore, appeal is continuation of suit. So with this, I conclude. So thank you all. Mr. Vikas Chatra, I have concluded my lecture. Yes. Mute ಮಾಡಿಲ್ಲ ಹೇಳ್ಬೇಕು ಸರ್ ಅವ್ರು ಹಂಗೆ ಮಾತಾಡ್ತಿದ್ದಾರೆ. Please unmute Mr. Chatra. Yes. Okay. Okay. Thank you. Thank you.